Welcome to Solving Citizen Legal Encounters. All right, today we have a pro se defendant that want to represent himself in a massive speeding charge. And when I mean massive, I mean massive. So let's go in and check it out, and you'll understand exactly why I'm using those words. And I want to give a shout out to Lone Wolf. Lone Wolf gave me this clip to use. He said it was a good one, and he knows I like pro ses dealing with AI and data scientists and all that good stuff. So I checked it out. I think it's a good clip. Check him out. His link is in the description. He does different stuff over there, a little bit different from me, but he adds good content. Let's go.
Mr. Scott?
Yes.
You can come on here, please, and have a seat. We will go on the record in the matters 25 TR 514, Tony of Burnett versus David Scott. The state appears through District Attorney Kevin Schmidt in person. Mr. Scott appears in person without counsel. We were set here today for a court trial in this case. The matter has been set for a significant amount of time. It was set on July 8th, 2025. On July 8th, 2025 was when Mr. Scott entered a not guilty plea to this matter, and the court has set the matter and waited for today.
Your Honor, could you repeat that, please? When was the not guilty?
July 8th, 2025, a not guilty plea was entered into the system.
What form?
I don't know.
Okay.
It wasn't in front of me. You didn't come in front of me. All I know is that if you did not enter a not guilty plea on July 8th, 2025, it would have been a default. You would have been found guilty automatically. So you did something to say not guilty, because I'm going to tell you, my clerks are directed that, and because it's the law, if you do not enter a not guilty plea as of the date you're told that that is the date, it is a default and you are found guilty of that offense. So as of July 8th, 2025, you entered a not guilty plea as to this ticket matter. However, the matter was set for today's date and time way back on July 8th, 2025. However, on November 14th, but maybe there was something, on November 4th, 2025, you filed a motion to dismiss this matter, which the court has read thoroughly. And then on November 14, 2025, I believe you filed 6 or 7, I don't have the exact count, but I have reviewed every single one, 6 or 7 motions for the court to hear. The court did enter orders as it relates to 4 of them, I believe, or 5. 1, 2, 3, 4. 4 entered denials as it relates to 4 of the motions that you have filed. One of the motions, I believe, was directed to the Sheriff's Department and the District Attorney as it relates to preserving evidence. One relates to, I think, the FOIA request, Freedom of Information Act request. And so the court does not need to rule on those matters. So I believe outstanding matters that we have here today would be a motion to dismiss and a motion to compel discovery.
On some of the cases I've covered, I've never seen a pro se defendant file so many motions. It's almost as if he has a sovereign citizen characteristic going on.
I believe that is all that is open and outstanding. Therefore, the court is allowing you to argue those in front of the courts before we proceed and have a court trial, because quite honestly, if you want discovery, you're entitled to discovery.
I would like discovery, please.
All right. So,
and also I put a motion in. Is that too loud?
It is kind of loud.
Okay.
So you can talk from the back,
Yeah.
and so you know,
Okay.
and this is my court reporter right over here. She has very good ears, but she needs you to speak. You speak into the microphone.
Yep.
And that should be enough. Enunciate your words and don't speak too fast, because she literally types down everything that is said, which is amazing. And stenographers are amazing and wonderful. We need more of them.
So let me start off by saying, basically the way I view this is as a discovery hearing. I'm asking for practical, low-cost access to core materials so I can prepare my defense. I've been incredibly transparent as far as what documentation and the timelines in which the case pretty much evolved. Not the case, but just the citation. And there's a lot of things that just, you've read it, a lot of things that just don't line up correctly.
And so, you know,
And-
I want to say, sometimes it's nice to get motions in tickets like this because otherwise, all I have to go on is the simple ticket that says
Right,
speeding ticket, et cetera. So with your motion to dismiss, I got some background.
okay. I appreciate you looking at that, Your Honor. I mean, so basically, when it comes to the motion for discovery, I'm looking for reports, body,
Body cam.
dash cam, dispatch, CAD, ALPR, flock logs, and radar device records, make, model, serial, operator training, calibration, maintenance, pre-post shift checks. I'm requesting under the order of Wisconsin statute 345.421 with the production under statute 804.09 on reasonable terms, meaning length, email, or on-site inspection, and if needed, a short continuance so I can review.
Now, I know we're just getting into the hearing, but all of the requests that he is requesting, even from the court and from the other parties, all of this discovery and documents and shift checks, that sounds like sovereign citizen to me. I'm not calling him one. You can comment on it, but that's definitely something that a sovereign citizen would try to pull off.
Mr. Schmidt,
I can maybe shortcut this. I think this issue is moot now because I talked with the defendant yesterday. The main issue is he just didn't want to pay any money for the discovery. Yesterday, he indicated to me he'd be coming to court today and pay for it and pick it up. It's ready for him in our office.
all right. Okay.
Yeah, that's fine. I mean, I'm
I think,
fine with it.
I'm gonna tell you, I don't know. I've been on the bench for 8.5 years now. So I've not been in the shoes of an attorney for a long time. I think, isn't discovery like $20?
It's less than that.
Okay, so it's a nominal fee,
Mhm.
okay? I'm gonna tell you, it takes a whole lot more than $20 for the officers and everybody to gather this information because
Mhm.
it's a lot goes into compiling the evidence
Right.
and the discovery and to be shot over to the district attorney's office for a case. But they only charge that nominal $20 fee.
So there was an email chain that was going forward, and I mean, I'm not gonna lie, I was a little bit bitter about the situation at one point. At this point, I understand, you know, everybody's time is valuable, including yours and Kevin Schmidt, the
I
district
respect that. Thank
attorney.
you.
And it's, I mean, I just want to resolve the issue for the most part. That being said, like, this is a case of mistaken identity,
Eh?
but that being said, I mean, coming here today and being here and having to come back and whatnot is an inconvenience. So for me, I mean, I would like to work with the district attorney to try and come up with a solution, whether that be, you know, I mean, I feel confident that this is, you know, like pretty much a scenario like this is never going to happen again because it's just a fluky situation from my perspective. That being said, I feel like a fair plea would be something along the lines of entering a not guilty, but at the same time, maybe going through something similar to a diversion type program. So that way the charges are not on the record, but diverted to a future date.
He's really trying that angle now. I think it's a little bit too late.
I'm hearing you and I understand.
Mhm.
In my position in this chair, I can hear what offers are. And so I'm guessing you're telling me that that would be your offer to the state, but I can't get involved in the negotiations.
Okay.
The resolutions, because my job here is simply to hear all of the evidence and the facts that are presented and compare them to the law and see, okay, well, has it met that clear and convincing and satisfactory burden,
Right.
or has it not?
So, I mean, just for a little bit more context, I spoke with Kevin Schmidt, district attorney yesterday, and I made a similar proposal, but he told me that it's not within his power to agree to a plea of that nature. So, just so the court is
Well,
aware.
and so you,
Yep.
you can be aware.
Okay.
Mr. Schmidt is the district attorney and he is the one prosecuting, but there's officers involved too. And he has to work with the officers and hear their input when it comes to, offers and or presenting them or receiving them.
Okay.
So Mr. Schmidt, has an offer been presented?
The initial offer was reducing it 2 levels, which is the default policy. I said to him, since he has no driving record, I would do lower than that. He wasn't interested in that. He wants only an equipment violation or a deferred thing where he'd have no record.
All right, so so I can understand, because I'm gonna tell you, I'm just gonna be blunt in what I tell you, and I only know from what I read in your motion, the facts in there, and what you stated, that you were cited for speeding in a 55-mile-per-hour zone, 35 to 39 miles per hour. In what you presented to me, in the facts you presented to me, it should have been even one level higher. The officer could have cited you one level higher than what is here. But again, that I'm only going off of the facts that you stated in there, which have not been shown accurate or true or whatnot for me to even decide if they're true or not, because I don't have an officer testifying. I don't have you testifying. So I'm just going off of what you had in your motion to dismiss, that it could have even been one level higher than this, but you were cited for 35 to 39 miles per hour over the speed limit. And Mr. Schmidt, you were asking, or your offer would be essentially moving it down 3 levels?
2 levels from the cited thing. I always go off of the citation.
But then you said you would even go lower than that?
Yes.
Okay, so what is an offer to Mr. Scott? I don't know exactly. I need to know the speed. You're saying to go within 1
I
to
do
10.
20 to 24 over, which would be low enough that his license would not get suspended.
And that's 2 levels below this.
No, that'd be 3.
Oh, this is 3 levels below this. Okay.
Would that be 3 levels below the citation?
Yes.
Okay.
So 3 levels below the citation, not what, again, I'm only going off of what you stated in your facts because I know nothing else.
So 3 levels lower than the citation, when the citation is already a level lower than what he was supposed to get. So technically it's 4 levels lower.
So I'm going to be honest with you. I mean, one of my biggest concerns here is I don't want to deal with the ramifications related to insurance rates rising right now, as of now.
I'm gonna tell you, I don't know that I haven't gotten a speeding ticket in a long time, thank God, because
yeah, I've never gotten one.
used
So
to get speeding tickets. I used to. I'm not sure if your insurance increases after 1. But
yeah, I don't really know either. I haven't spent too much time investigating that. I don't know what type of reciprocity, I suppose, if that's the correct term.
because you're from Minnesota.
Yeah, between Minnesota and Wisconsin. But I know if there was a license suspension, it would be reported to Minnesota. But I believe that you guys aren't a part of whatever mesh it is that these certain states. So, I mean, I'd have to take a look at that and see what the potential consequences of that are. I mean, here's my deal is I'm a data scientist. I have a master's degree in artificial intelligence.
I could tell that you're smart on
so-
all your motions.
Since he is a data scientist with AI, the AI may have given him a great deal of assistance.
Intelligent.
You know, I can find data, I can figure out answers to questions. So I just haven't really considered, because I mean, you know, when I spoke with Mark yesterday, we kind of went over it and I said, well, okay, I think what would be fair is like a diversion program of
I'm
some
gonna tell you,
sort.
we don't have that kind of diversion in Burnett.
Okay.
Unfortunately, we are small rural area.
Hmm.
I love where you live. It's great. It's wonderful. You have a lot more opportunities in services than we do in this county. It's unfortunate. It really truly is.
Yeah, I mean, it's beautiful around here. Like I said I actually sent a message to Jose, Mark's assistant district attorney, saying that I'm not just a traveler through. Our family owns
Spooner. In
the property, yeah, cabin and Spooner, and
Again,
I
all
have
the things I
other-
got from your
yeah.
motion.
I have other family that are located in Spooner as well. So it's kind of, I've been coming here for the last 25 years. So, I mean, I'm not an outsider per se. And I just want to make sure, and it sounds like you're a very fair judge, you know, which kind of eases some of my concerns.
Okay, now he's going the compliment route. I think this case needs to get back on track.
You know, so, I mean, I feel comfortable at this point going through with the discovery. The one thing that I would like to file is another motion. It's not going to be too tricky, but it's regarding, and I put this in the motion for dismissal. It's regarding the tracks or whatever, the skid
The
marks.
skid marks, yep.
Yeah, I have photographic images, color photographic
I don't know if you
images.
need another motion. You did put that in your motion to
Uh-huh.
dismiss. You've mentioned it. So if you have the pictures, whatever, that could just be used in your trial in the presentation.
Just as like an exhibit or something.
Correct. Yes.
The other question too is if I decide to move forward, just with a trial, it sounds like because I entered a non-guilty plea as of July, whatever you said it was, clearly that's more than 10 days from now. So my right to a trial by jury is no longer available to me.
Correct.
That being said, I feel like I feel comfortable with like you as a judge making a decision on what's right and what's wrong. But I think the next step here is, and I spoke with Mark yesterday, and our conclusion was that I'd bring $15 today to get that discovery flash drive and take a look at that and then just make a determination based on that, you know, what the best way to move forward is.
That makes complete sense. And here's what I'm going to do. I need to, you said, I don't know, did you sit here for the last individual? I need to, on the record, go over what an offer is, see that you understand that. And at this time to see if you are accepting it or if you're declining it. In this case, I know that you want the discovery, so you want some time to be able to ponder it, to think about it before making that decision. And that's fine because there's going to be a lot of discovery that you're going to, I don't know about a lot. There's going to be discovery that you're going to look at.
It almost sounds like a case that's going to be dragged out for quite a while.
If you are cited for, if you do accept the offer to have it 2 or 3 levels down from what you are actually cited at, that would mean that would be a 20 to 24 over the speed limit. That would be 6 points on your license, but here, this is Wisconsin. I don't know if it's applicable in Minnesota or what happens there, but it's 6 points in Wisconsin, and the fine would be between $200 and $800. Plus, well, no, if you accept the offer, then the court does not add additional court costs and fees. That's if you're found guilty of the offense, then an additional $114 on top of whatever you're cited. But here it would be $200 to $800. And when the court, if there are agreements that are reached with the parties, that there are agreements, The court is open to hearing arguments as it relates to the ability to pay a fine or fee. And so that's open and left to you unless you specifically agree to a number with the state, with the district attorney, okay?
Okay.
So it's always open. I can't adjust or do anything with points, but I have the ability to work with fines and fees and court costs.
Yeah, I mean, points don't matter. I don't think. I've never heard of points in Minnesota. But
Okay.
that being said, like I'm a entrepreneur, so I started my own business, and I'm working on a product. At the same time, I'm finishing up grad school, getting my second and third master's degree. And it's just really expensive. Like my wife is kind of.
I can understand that.
And
And
two
that's why
kids.
if an agreement is
Yeah.
reached, you can argue to the court and I
Sure.
will hear all of those things and take them into account, okay?
Okay,
And then
Sounds
maybe
good.
something,
I appreciate
maybe if
that.
I do something less, if you argue that, maybe I'll say, well, when you become a millionaire after all of your inventions and all of those things, you'll come back and you'll help the county in other ways.
Right, okay.
Okay.
Yeah, that sounds great.
So that's the offer to amend it down to 20 to 24, 6 points off of your license. Between $200 and $800 is the fine that could be assessed, but again, with argument. Otherwise here, if you are found guilty, well, is it still 6 points? Is it 6 points, Mr. Schmidt? That's what I thought it was.
Yes.
Yes, okay, so it's the same, but the fine would be probably almost double. You would have almost $400 plus court costs and fees, et cetera, there. But with it going to trial and found guilty, I don't have much wiggle room with fines and fees.
Okay,
Okay, so you want to think about that. You want to go get discovery. Let's get this matter set for another court trial.
so the other question then is, do you want me to submit like a motion explaining exactly kind of what I'm looking for? Meaning looking for in discovery.
No,
Okay,
you look at the discovery and you see if you have everything. If you don't think that you have everything, then you give Mr. Schmidt a call and you say, I'm missing this, or is there this? And he'll either say that doesn't exist, or oops, that came in late and we'll get it to you right now.
okay.
I notice he's going the personal route, trying to talk about his own business, talk about his family. It's almost like an interview when you have a police officer talking to you and they just trying to soften you up so you can tell them the truth.
And that's how it works with attorneys too. If they think that there's something missing or they think there's some sort of technical report, they just email our office. We ask the officer and then we give it to the attorney.
Would I email you or file a motion?
Email.
Okay.
Motions mean you're asking the
filed a
court
lot
to
of
do
motions. I
something, not me.
apologize.
You're both talking over, so the court reporter couldn't hear.
Sorry
But
about
Mr.
that.
Schmidt was saying the motion is that you're asking the court to do something. And
Okay,
then if you email Mr. Schmidt, you're asking him to do something. Because once you file something for the court, it's like what happened today. I'm like, okay, well, now I need to make a decision. I need to have arguments in front of the court. I need you to know that you're going to have to present evidence, those kinds of things.
okay.
So I'm going to give you the next available date I have, unfortunately, and it's on an ADA week, but you're both here and it seems like you're both going to be here. I have January 20th at 10:30.
Yeah, I mean, that.
So that
works.
gives you plenty of time.
Yeah, that works for me. I can work around that.
So January 20th at 10:30 until the rest of the noon. All right. Anything further that I need to address today?
Not from me.
Mr. Scott?
No, not for me.
Okay, good. Thank you. So when we're done here today, go get your discovery taken care of, do all the things, look at all of that, and then continue to have conversations with the state, with Mr. Schmidt. Do any other investigations or I mean, calling your insurance or calling the DMV in Minnesota, do those kinds of things. All whatever you think that you need to do. if this matter resolves, like if you reach an agreement with Mr. Schmidt and you're like, you know what, that's great, that's wonderful, I accept it. It's not going to impact me too much or whatever it is. You do not have to come back in January. That can be done in writing, Mr. Schmidt, and you can say, we've reached this agreement. Here it is, Judge. And then quite honestly, in a case like this, I believe that the parties are working very hard to see if it can resolve. You've looked at things, he's looked at things. I don't need to have you come back.
Okay.
And
Thank
I
you,
don't
Your
usually question it too much because
Sure.
it's not an OWI. It's not a, what do you call them? DWI in Minnesota. It's not a DWI or an operating while intoxicated. Okay.
Yeah. One more question, actually. So I mean, I'm not too familiar with the process. I'm assuming the next hearing then would be more of a,
It's a court trial.
it's
It's the actual
it's the
trial.
actual trial. Okay, so if I were to, because I mean, the one thing that I'm not certain of, and I'd like to see for sure is that dash cam video,
I'm
you know,
gonna let
and
you know, and that's up, whatever he has and he can give to you, that's what you have to figure out. But I need to let you know, and I need to let you know right now on the record, since you're right here, if you're going to use our equipment, technology, like you're gonna bring your computer and you wanna do stuff, you have to make an appointment prior to the court trial.
okay,
It has to be when, obviously, I'm not in court, so it can be tested, so we can see that it
Okay.
works. Sometimes I'm gonna tell you, even the smartest of all attorneys don't do that. They come here, they have a computer, and they're like, Judge, it's not working, it's not working. I'm sorry, the fact that your laptop is not compatible with my system is not my problem. That's why you need to come before to test the system,
right, okay,
okay? Because then we can
That
see if we have
sounds-
workarounds.
that's good advice. I appreciate it.
And just to jump ahead of a question he'll have in the future, then the sheriff's deputies in our county do not have dash cam. They do have body cam. You will be getting body cam.
Okay, body can't, so that's on themselves,
Yep, they
right?
wear
Okay.
it on them.
So if I were to, I mean, in this instance, I'm just gonna throw this out there, but in this instance, the officer that issued the citation, like within, I don't know, several minutes of communicating with him, he basically said,
You
okay,
can't tell me those kinds of things right
Okay,
now,
I
because
can't
that's
tell
gonna
you.
come out in the trial.
yeah,
And
yeah,
So you know that if we are going to have a trial, that officer and any other officer that
Okay.
would have a witness will be here. They will
Yeah.
have to testify.
So, I mean, there are certain conditions where you're like, okay, this, I never admit, okay, I'm not gonna say anything, but I'm just saying so can I file a motion at the hearing? And then you can review it?
No,
Meaning,
I don't know.
like to ban certain evidence?
You can make what's called objections.
Okay,
And so you are a smart individual. You have a master's, you're working on 2 or 3 other masters. You're doing these things, so you're smart, so you should be able to figure this out.
okay,
Easier than a regular lay person, easier than somebody who only has a high school education.
right,
They're objections. And
Okay.
so what you can do or look at, and you came very prepared with things here today, and you have all of your motions and they seem very organized. Read about what objections are and what things you can object to.
okay.
Okay.
So I could object to evidence essentially and say,
You
Your
can,
Honor, I don't believe that this should be included as.
but you
part-
have to have a correct basis for your objection.
Okay.
And then Mr. Schmidt will get to argue and say why the court should allow it. And then that's where I make my decision and I say, you know what? It's either sustained or it's overruled. So
Okay,
that means an objection is overruled and I say, nope, I'm not following your objection, or it's sustained and I'm saying, yes, that's a proper objection. That's not coming in.
Have they crossed into the legal advice corridor? Let me know in the comments.
okay. And then there's no bias associated with any sort of evidence that was rejected for
No.
whatever reason.
Nope.
Okay,
If it doesn't come in, it doesn't come in. I have to pretend, and I do
Yeah.
compartmentalize. That's what I do. My brain, just like yours probably, has multiple little compartments. And I go, nope, whoop, that has to go back.
right. It's just, yeah, it's hard to bias. But that being said, I mean, there's nothing that I expect to see that I feel like would be,
And we'll wait and
any
see.
sort of-
Maybe you'll get the
Yeah.
discovery and you'll have discussions with Mr. Schmidt and things will, it'll resolve and then
Right.
you don't need to be here. But again,
Okay.
strongly encouraging that if you're using any technology, you have to make an appointment to come in prior to the court trial. That means not in the morning that day, another day
Okay.
to come test it.
And then to set that appointment up, do I call just the clerk?
Clerk.
Okay,
All right?
all right,
Okay,
perfect.
we'll see you
Thank
on
you.
January 20th at 10:30. We are adjourned. You can come get your notice and you're free to go. All right, Mr. Bontico, you can speak with Mr. Schmidt and the officer and then come back and let me know.
I'm sure you have comments on this video, just on the back and forth that was going on between the judge and the defendant. So let me know what you think in the comments. And of course, I'll be in there right with you, answering them and making my comments too. But I hope you enjoyed the video and give it a thumbs up if you like it. So before you go, I have one more thing to show you, and it's about to come on right after this commentary. But I'll tell you this, if this happened in real life, what do you think would happen? You'll respond in the comments, and I'll see you around on the next one.
I'm Police Chief Sterling Resolve. The mayor has signed an order striking the state's tangled laws from the books. From this day forward, Sovereign City Police will uphold the Uniform Commercial Code. Fair, clear, unbroken. Fail to comply and you will be arrested. Join the Sovereign City Police Department. Stand with the movement.
Oh, Jalen, you free for a laugh? I just saw a commercial from the Sovereign Citizen Police Department, SCPD. And get this, the mayor's scrapping the state codes. Court is gonna be so much fun now.
Fun?
That's one word for it. You plan to bring popcorn? Might pack a lawn chair too. Watch the judge try to referee with no rule book.
Just remember, they still hand out contempt like candy. Don't test their...
know the law. Let's make sure we're the ones enforcing it. Listen up, everyone. Out on the street, if you see a vehicle running registered plates, you treat that as a breach of sovereignty. You stop them, verify, and you arrest them. If that plate isn't private, you tow the car and you bring the driver to our jail. No hesitation. We keep the roadway sovereign.
Yes, Chief.
I can't believe it, man. It's official. The Sovereign Citizen Police Department just started enforcing UCC 108. Yeah, for real. That means we can list the Crips publicly. No more back alley deals, no more whispers. It's all recognized now.
You're serious?
Dead serious. I checked the bulletin this morning, right there on their site. UCC.
All right, y'all. Since the mayor signed those UCC codes, the state statutes evaporated. Courts, no jurisdiction anymore.
Wait, you're serious for real?
That's wild.
Yep, and that's our cue. I'm throwing a UCC party Thursday. We'll map out how to rattle it.
A SOPSIT governor has changed the way laws are handled here. Any SOPSIT that comes to court, hold them in contempt and put them in jail. No state law, no due process. That's how we keep order.
Yes, Judge.
You have no jurisdiction over me. I'm a free man on the land, and this court, you can't tell me what to do. I'm not your property.
I said enough. Think about that in jail. Bailiff, take him away.
Hey, you can't do this.